Trump administration and its Department of Justice is picking on the wrong federal judge, barking up the wrong tree, if you know what I mean. And I don't mean Judge Jeb Boasberg. I mean Judge Beryl Howell, who's now not only rejected the Trump administration's call to have her recuse herself or be disqualified and removed from the case in which she just entered a temporary restraining order that the Trump administration doesn't like to stop them from retaliating against law firms like Perkins Coie out of Washington, trying to effectively put them out of business. She restrained them from doing that. She restrained them from attacking them. She restrained them from firing them or making sure their clients were fired from all government business because she found they made a First Amendment violation in doing so. And now Donald Trump wants to retaliate against Beryl Howell, and Beryl Howell has fought back with her own 21-page order in which she takes the Department of Justice to task and Donald Trump to task as well. Nobody better suited to do it than Beryl Howell, who once presided over many aspects of Donald Trump's own criminal trial, who presided over the $148 million defamation case and judgment against Rudy Giuliani, who sentenced and presided over many Jan 6 cases that had to deal with the dismissal of many Jan 6 cases because of Donald Trump's pardon. There's nobody more situated than Beryl Howell. Let me break it down for you. I'll read to you from the most compelling parts of her order and tell you what it means going forward. It's been a losing 65 or 70 days for the Trump administration in every way, including in the courts, including in their implementation of their obvious transparent strategy to beat up federal judges, to beat up lawyers and law firms and judges and media people and the rest. It's all for naught. You're on Legal AF. I'm glad you're here. Let's get into the memorandum opinion and order of the judge that just came out yesterday. The judge starts with, just because you're losing, don't attack the messenger. Here's what she says. When they say she's biased, I'll give you the outline of the disqualification motion. Beryl Howell should recuse herself because she's biased. Why is she biased? Because she presided over the grand jury proceedings that stripped two of Donald Trump's lawyers of their attorney-client privilege along with Donald Trump and made them testify against him, leading to his indictment and prosecution. Right, because she made a determination under fact-finding that they and Trump likely participated in a crime or fraud related to Jan 6th. And prior rulings cannot form the basis of a recusal or disqualification motion. That's well-settled law going back a couple of 100 years. So take that off the board. Their other argument is they don't like the one line in a comment she made at a speech she gave last year in which she accepted an award in D.C. And she talked about the slippery slope of moving towards authoritarianism and totalitarianism and the impact of the big lie. This is while sentencing was still going on for Jan 6 people. Now, Elise Stefanik, who's now the UN ambassador for Trump, then a congressperson, filed an ethics complaint against Beryl Howell that went absolutely nowhere. She filed it against other judges as the chosen pit bull attack dog for the administration. And what Beryl Howell doesn't like is that the same language that was used by this now former elected official is showing up and creeping up in the language used by the Department of Justice. And that's not what she said. She didn't attack Donald Trump by name. She didn't attack any of the cases. She's allowed to speak her mind about things in her First Amendment as long as she doesn't mention pending cases or cases that could likely end up before her. So that's two. They don't like the fact that after Donald Trump pardoned all of the criminals that attacked our Capitol, who were convicted of many of them, convicted of violent crimes, including against law enforcement. And there were 5 deaths that happened off of Jan 6. They don't like the fact that she refused to dismiss the indictments or the cases with prejudice, meaning never to be filed again. She did it without prejudice, which is her prerogative as a federal judge. They didn't like that either, and so on. And so the judge had this to say in her order. The opportunity presented by the defendant's motion, the Department of Justice, to disqualify this court is welcomed to set the record straight because facts matter. That's page 1. To begin with, this court agrees wholeheartedly that defendants that fair proceedings free from any suggestion of impartiality, free from any suggestion of partiality are essential to the integrity of our country's judiciary. She then says on page 2, the fundamental promise, however, does not entitle any party, not even those with the power and prestige of the President of the United States or a federal agency, to demand adherence to their own version of the facts and preferred legal outcome. Fact-finding, after all, is the basic responsibility of district courts, and she cites cases as far back as 1803 in Marbury versus Madison. This reminder about the role of the federal court seems necessary, given the opening line in defendant's pending motion. Here's where she chastises the Department of Justice on the bottom of page 2, expressing, quote, the need to curtail ongoing improper encroachments of President Trump's executive power playing out around the country. This is their bleating, complaining, whining about all their losses before multiple federal courts and federal judges, federal district courts, federal appeals court, even up to the United States Supreme Court. It's one big loss. They've had a couple of wins here and there, but it is about a 90. The winners, the plaintiffs, are batting about 900. Those are Hall of Fame numbers, son. The judge continues. This line about ongoing improper encroachment of the executive power around the country, this line, Judge Howell continues, sounds like a talking point from a member of Congress rather than a legal brief from the United States Department of Justice. Has no citation to any legal authority for the simple reason that the notion expressed reflects a grave misapprehension of our constitutional order. Adjudicating whether an executive branch exercise of power is legal or not is actually the job of the federal courts and not of the president or the Department of Justice, though vigorous and rigorous defense of executive action is both expected and helpful to the courts in resolving legal issues. We like adversarial process. That's the basis of our justice system. Defendants then proceed, this is Trump, in the second line of their motion, to describe as meritless every lawsuit challenging the president's agenda that the American people selected him to carry out. This blanket denigration of the merits of all lawsuits filed across the country certainly reflects palpable frustration with court rulings issued to pause, temper, or reverse Trump administration actions. But this is a testament to the fact that this country has an independent judiciary that adheres to an impartial adjudication process without being swayed merely because the federal government appears on one side of a case and the president wishes a particular result. She continues on page 3. While obviously not able to speak to all the merits of the cases around the country, provoking the defendant's frustration, a quick survey over which this court is presiding challenges the current administration's actions, shows that contrary to the defendant's posturing, the outcomes have followed the facts and the law. When the facts and applicable law appear likely to favor the actions taken by Trump, for example, this court and all the judges in the District of Columbia have ruled in the government's favor, and she cites a number of those. In another case, even the government conceded that binding Supreme Court precedent required the legal result reached by the court. And then she said there's other times when they lose, and then there's times when they win. On the bottom of page 4, she says, defendants rely on speculation and innuendo in seeking to get another judge assigned to preside over this case. The clear absence of any legitimate basis for disqualification requires denial of this motion. They cannot prove that her impartiality can be reasonably questioned. She then went through piece by piece all of their stitched together make-weight arguments without merit about why she should be dismissed. Prior rulings against Donald Trump, a speech that she gave, how she handled the Jan 6th insurrectionist sentencing and their pardons and their dismissals and the rest. And then at the end, she talks about this particular case. And she says, look, I understand your argument that Perkins Coie was somehow involved with the Steele dossier, which has been discredited, and the Durham investigation by the special counsel, which led to one criminal investigation, or actually 2, and no convictions. I get your point. I'm not dismissing it. I'm just telling you I don't agree with the facts that you're pushing or that you're arguing, and that's not a ground to have me removed. I'm not even sure where Donald Trump thinks a better federal judge would be. I guess somebody like Carl Nichols, who was appointed by Trump. There are a couple of Trump-appointed people, but Carl Nichols hasn't been great for the Trump administration. A couple of places he has. I think they're trying to spin the wheel, but it could just as easily land in Judge Chutkin's lap or Judge Boasberg's lap. He just got another case assigned to him involving Donald Trump. when they got sued related to the Signal Gate and the leak of military grade intelligence and war plans. That has got assigned to Boasberg again. But they rather take a shot. You know, I always think the devil you know is the better than the one you don't. And they're just forum shopping. They're just judge shopping. She's allowed, this is how it works procedurally. Judges are allowed in the first instance to decide whether they're going to be recused or not, or disqualified. And if you don't like it, you can try and appeal. He can try and appeal to the D.C. Court of Appeals. It's not going to work there. And there's no way the United States Supreme Court is going to remove Beryl Howell from this particular case because she entered a temporary restraining order. I'll continue to follow it all here on Legal AF. Take a moment, hit the subscribe button. We're continuing to grow this pro-democracy channel in collaboration with the Midas Touch Network with a whole band of new contributors coming on Monday, led by Dave Arenberg. So until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.